Hey, it's Mauricio here, and today we're going to talk about part 2 of our 10 most common mistakes real estate investors make after they close their properties. Now, if you haven't looked at the original video, please go check it out. It's up here in the corner somewhere. But in that video, we discussed the first 5, which were as follows. Number 1, holding your assets in your personal name. Number 2, not separating your assets from your liabilities within your entity structure. Number 3, not thinking about privacy. Number 4, relying on your living trust. And number 5, relying on insurance. Now, the 6th most common mistake is waiting too long to put some type of a plan in place. My 2 favorite quotes on this, one is, I think it's a John F. Kennedy quote that says, "The time to repair the roof is before it starts raining." And then my good friend Robert Kiyosaki likes to say, "The time to put your seatbelt on is before the crash." So you want to make sure you're putting these asset protection structures in place before not only the lawsuit, but before you even know or reasonably know that there's going to be a lawsuit coming. So if you get into a car accident, it's going to be too late to then go out there and talk to somebody, an attorney or an entity structure, to start transferring assets into LLCs to protect yourself, because there's something called fraudulent conveyance, meaning the judge will unwind that transaction if you took an asset out of your personal name and put it into some asset protection structure, but that happened after the accident, after you found out about the claim. The judge has the power to unwind that transaction, and they're going to be able to get to it. So if you're going to put together an asset protection structure, which I recommend everybody doing, make sure you do it before you find out there's a potential claim. Mistake number 7, relying on single-member LLCs. Single-member LLCs don't have the same asset protection value as multi-member LLCs, and unfortunately, when it comes to husband and wives, though they are considered one single member, the protections that are afforded to single members sometimes don't exist, and it makes sense, and let me tell you why. The whole idea of this protection when you have multi-members is that if you're in business with somebody, right, you have a business partner, and that business partner gets into an accident, that person gets sued, and they lose, let's say it's a 50-50 partnership, they lose 50% of the company to a creditor. Well, hey, I'm now stuck with this creditor, 50-50 partners with this creditor who has no interest in running the business with me, no interest in growing it, no interest in doing anything other than liquidating that 50% so that they can go get their money and move on with their life. And so there's this public policy that says, look, if you have a partner, a multi-member entity, then we're going to give you charging order protection, which means they're not going to be able to get your 50%. You're still going to be able to run the day-to-day with your partner, but any profits that would have gone to your partner are going to go to the creditor. So at least from the co-partner, it doesn't really affect their business at all. It just affects the person who owes the money. They're going to have to give that money, all of it or portion of it, to their creditor. But when it comes to a single member LLC, that public policy doesn't really make any sense. It's just you. You don't have any partners to worry about. So most states don't recognize or don't apply the same charging order protection on a single member LLC as they would do on a multi-member. And if you haven't seen my video on charging order protection, I would encourage you to go check that out. I'll put it up here in the corner again, because that is sort of the bedrock of LLC protection, but it doesn't apply to single members all the time. So whenever possible, make sure you structure your LLCs where there's at least 2 members. Mistake number 8, and this is the big one, is commingling your funds, either with other LLCs or with your personal funds. What we're trying to do is we're trying to make sure that each LLC operates individually, that you treat them separate, that they have separate bank accounts, that they have separate EINs, that they have separate books. You're really respecting that independence from each entity, because legally these are separate entities from yourself. But if you start commingling and starting paying some expenses of one LLC with the bank account of a different LLC, then you're going to be commingling those funds. Then any judge is going to say, well, look, you're not treating these separate. So if there's any issue with one LLC, we're going to basically combine those, and you're going to there's going to be liability on both. And same with your personal. If you start using your credit card, your business credit card, to go buy groceries or to go buy, personal items, then even worse is if there's a judgment against your LLC, which is what you want, they may actually be able to pierce that veil and actually get to you as the owner where they ordinarily wouldn't get to, because you didn't respect those boundaries. You've got to respect the boundaries and make sure you do not commingle your funds. Mistake number 9 is that if your estate is large enough, meaning you've got, 5 million, 10 million or plus in assets that you own, a big mistake is not considering an asset protection trust. Setting up LLCs, that's the first level. That's sort of the basic. Everybody should do that. It's relatively inexpensive. But if you're at a higher level now and you've got real assets to protect, again, millions of dollars of assets, then you really want to talk to somebody about having an asset protection trust, whether that's domestic or offshore, again, depending on your situation. But have that conversation with your attorney. This is separate from a living trust. We talked about in part 1 that a living trust has no asset protection value whatsoever, and that's because it's revocable. I can change my mind, I can do whatever I want. An asset protection trust has asset protection value, is probably the strongest asset protection entity because it's irrevocable. Once we set up an asset protection trust, I can't go in there and change it and do this or do that. And so it really is considered a completely separate entity that actually doesn't have any owners. Like, I actually don't own my trust. I'm just a beneficiary of that trust. So if you've got a large estate, look into having an asset protection trust to make sure that you're as protected as you can. And mistake number 10 is not considering the state that you reside in your analysis. I'm a perfect example because I live in the great state of California. California probably has the worst asset protection laws out there, along with some other states like, Georgia and a few others, not to call anybody out. But you want to make sure you understand where you live, because in some states, like if you lived in Wyoming, for example, I would have a completely different entity structure than I would if I lived in California. California, in addition to being a terrible asset protection state, you've got franchise taxes to deal with every LLC, so we don't want to create too many LLCs. So there's some additional things that I would look at if I was looking at an asset protection plan if somebody lived in California versus Nevada versus Wyoming versus Texas or even versus Florida. Florida's a great example where, a multi-member LLC is fairly well protected, but a single member LLC has absolutely no protection, which is something we talked about earlier.